Hello, and welcome to Epstein Becker Green's webinar entitled Medicare Enrollment Revocations, the Government Enforcement Initiative You May Not Know About. Before we begin today's presentation, please be informed that today's webinar is being recorded and the participant phone lines will be placed on mute throughout the program. You're welcome to submit questions throughout the program by using the Q&A feature provided by WebEx. And at the end of the program, with time permitting, the speakers will address your questions. You're also welcome to submit questions directly to the presenters following the webinar. Contact information will be displayed at the end of the presentation. In approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to the PowerPoint materials. We are pleased to have 2 fantastic speakers today, Epstein Becker Green's Rob Wanerman, who is a member of the firm in the healthcare and life sciences practice in Washington, D.C., and Yulian Shtern, who is an associate in the healthcare and life sciences practice in the Newark office of Epstein Becker Green. At this time, I'd like to turn the webinar over to Rob.
Okay. Thanks, everyone, for dialing in. And we hope this is a good introduction to a healthcare enforcement authority you may not know about. And that's CMS's authority to revoke a provider or supplier's Medicare enrollment. If you need a citation, the citation is 42 CFR 424.535. You may not know about this authority because it's not publicized the way that exclusions that are imposed by the Inspector General or penalties that can be imposed by the Justice Department are usually publicized. But it directly affects hiring and staffing of any healthcare provider or supplier, and it affects all supervisory or management positions within an organization. It doesn't get very well publicized, but the effect of a Medicare revocation can be just as devastating as an exclusion that's imposed by the Inspector General. So we're going to go through the authority that CMS has and how to respond rapidly to it, hopefully as part of your compliance program, because a rapid response really is required, and as we'll talk about a little later, failure to respond rapidly can have a devastating effect on any appeals of any revocations. So if we go to the next slide, I'll give you an introduction of some of the authorities. We put them into various groups. And the first group, probably these are familiar to many of you. These are revocations that are based on actions by other government agencies. So, for example, Medicare can revoke your enrollment if you have been excluded by the Office of Inspector General under Section 1128. Those are for program-related crimes, or an exclusion for a failure to refund a Medicare overpayment. Also, if action is taken by the DEA to suspend or revoke prescribing authority, that can be the basis for a revocation. Also, if a state Medicaid program revokes a provider or supplier's enrollment and it becomes final after a hearing, Medicare can follow suit and revoke as well. If we go to the next slide, this is where things get a little dicey. This is where CMS, the Centers for Medicare and Medicaid Services, can revoke Medicare enrollment based on their own authority. They don't need some other agency to act. And we've given a couple of examples here. One is noncompliance with any Medicare enrollment requirements. So if you're not in compliance with anything that's in that enrollment form, sometimes this happens with physicians and whether or not they're properly licensed. For example, this is based on an actual case. A physician did his residency in State A, got a license in State A, moved to State B, got a license in State B, and then decided to relocate to State C. Now, he thought he'd never go back to State A or B, and instead of putting his license into inactive status, just let it lapse. He didn't pay the renewal fee. Well, he goes to State C and enrolls in Medicare again. They do their diligence, they review his licensure, and they find a registry that says that the physician's license has been revoked in State A. and they deny enrollment. So that's one example. There are many others that we can give. They can also revoke on their own authority if a provider or supplier fails to update their enrollment information, all that information in the 855 form. That can include failing to notify the program of a change of location or an adverse legal action within 30 days of the event, or a failure to report any other type of material change in information within 90 days. Again, these are less familiar, but they can have the same effect. So that's sort of a couple of general bases. I'm going to turn this over to Yulian to go through some other items that are CMS-based.
Thanks, Rob, and thanks for including me in this webinar. Rob and I work on several of these types of matters, and I know Rob and I share some sympathy for the providers that face this, particularly for seemingly trivial reasons that they get revoked. So take this opportunity to learn more about the grounds for revocation of provider enrollment and how to possibly avoid it. And as Rob mentioned, these are specific, we're starting to get into specific reasons why CMS might decide to revoke a provider's enrollment status. The first one being providing false or misleading information. For instance, and this is taken from a Departmental Appeals Board case, certified registered nurse, and this was revoked for failing to disclose 2 license suspensions and license revocation in her Medicare enrollment forms. So in these circumstances, we typically see revocations where there's information left out of enrollment forms or information enrollment forms are inaccurate. And CMS can look back to previous enrollment forms too, so it's not just the most recent revalidation forms they might be filling out. They can go back and find other misleading things in prior applications. Now, Rob and I worked on a couple of on-site review revocations where providers found not operational or otherwise non-compliance with Medicare enrollment requirements. This is a controversial one, and Rob, let me ask you, what have you been seeing in the context of these on-site reviews and operational-based revocations?
A lot of the operational revocations are usually tied to things that surveyors will find when they come on site. That's typically for any hospital, nursing home, provider in Part A, also with home health agencies, and that's if the surveyors don't believe or don't find appropriate evidence that there is a fully functioning organization, they may determine that they're not operational, and that becomes, in addition to the survey that you have to fight, now you have to fight a potential revocation.
And just for our attendees' knowledge, the definition of what is operational for the purposes of provider enrollment is found in 42 CFR 405.502, and it basically requires a provider to have a qualified physical practice location open to the public for the purpose of providing healthcare-related services. It's properly staffed, equipped, and stocked as applicable based on type of facility or organization, or the service or items being rendered, to furnish Medicare items or services. So we'll talk a little bit more if we have time about these type of revocations, but they can come for a variety of reasons, as Rob mentioned, in the course of a survey, if surveyors find operational issues, or even if a provider lists a PO box as its practice location, which is not allowed in enrollment rules. That could lead to revocation as well. So moving on, revocation can also be issued for what's called a hardship exception denial and failure to pay enrollment fees. In other words, if a provider or supplier applies for a hardship exception for their Medicare provider enrollment fees and is denied and fails to pay the enrollment fees within a certain period of time, 30 days after receipt of the decision, CMS can revoke for those reasons. And lastly, we'll touch upon this briefly because we'll go in greater detail later on in this presentation, but misuse of billing number, in other words, allowing a different individual or entity to use a provider or supplier's provider number. This is not the same thing as a situation where we have reassigned benefits or Incident to services, but more so on the level of perhaps some kind of fraud or dishonesty in terms of who the actual provider of services is. So distinct from misuse of billing privileges is the abuse of billing privileges, and revocations based on the abuse of billing privileges is mostly based on problems with claims or services that are represented in those claims. For instance, a common scenario is when a provider supplier submits claims for services that could not have possibly been furnished. This is sometimes common where a provider submits claims for deceased beneficiaries. That doesn't happen commonly, but that's just one example of abuse of billing privileges. Otherwise, CMS can revoke based on a pattern of claims that fail to meet CMS requirements. And this approach to abuse of billing privileges is a little more nuanced and fact-based. CMS will consider the percentage of submitted claims that were denied, the reasons for denials, history of final adverse actions or enforcement actions, the length of period of the alleged abusive behavior, and other things that would lead to the determination that billing privileges are being abused. Another ground for revocation.
That's okay.
Another ground.
I'll jump in here just for a moment and
yes.
And just explain that this is an authority that CMS has. It's completely independent of authorities that the Inspector General's office may have that may involve the same conduct. So the two examples Yulian just gave, you could find a scenario where one agency acts and the other doesn't, or where both act.
That's right, and as we'll talk about a little later in the presentation, we'll see that sometimes the collateral consequence of these revocations also involve overpayment liability actions. The next ground for revocation is specific to home health agencies, and it is applicable when a home health agency fails to furnish supporting documentation verifying that they are meeting their reserve operating fund requirements. This is typically looked at upon the initial existence of the home health agency, and those funds are found in section 489.28A. And the last CMS-based grounds for revocation is a pattern of Part D prescribing that is abusive, a threat to health and safety, or fails to meet Medicare requirements. We anticipate seeing more of this in light of the growing opioid crisis and attention to prescribing opioids and other controlled substances that we've seen around the country. Haven't seen much enforcement of revocation for this particular grounds yet, but I think it's safe to say that that will be another remedy in addition to the various other remedies the government might have against providers that are overprescribing Part D drugs or opioids, et cetera.
So what is the effect of a revocation? It has several different prongs to it. First and most obvious is that if your Medicare enrollment is revoked, CMS will not pay for services that you furnish. That starts 30 days after you receive a revocation notice from CMS, unless it was for a felony conviction, an exclusion, debarment, or other government action, in which case they can backdate the revocation to the date of the underlying offense. And that sometimes can span several months or even a year. The derivative issue that arises there is that if they backdate the effective date, you may have a large Medicare overpayment sitting right there as soon as you get that notice. Also, if you are a Medicare Part A provider, a hospital, nursing home, home health agency, hospice, etc. A revocation automatically means that your Medicare provider agreement is revoked. It's possible to re-enroll after the end of the revocation period, but re-enrollment is not automatic. You have to reapply as if you are a brand new provider or supplier, and in the case of a provider like a hospital, nursing home, home health agency, that means you have to be surveyed all over again as if you are a brand new provider. It's, again, not automatic. You have to start from scratch.
So when a provider is revoked, they're subject to what's called a Reenrollment Bar. This, in effect, is a time period in which the provider cannot participate in Medicare after the effective date of revocation. Rather, not the effective date of revocation, but the effective receipt of notice of revocation. Because in some instances, as Rob mentioned, there are grounds that CMS can retroactively revoke a provider, such as felony or operational issues, which we'll talk about in a bit. But the Reenrollment Bar begins 30 days after CMS sends notice of revocation and typically lasts between 1 to 3 years, depending on the severity of the offense leading to revocation. For some grounds of revocation, these time frames are particularly stringent, such as felony convictions. They're always 3 years if the revocation holds up. On-site review, non-operational status is a 2-year re-enrollment bar. Some of the grounds that are more, have some wiggle room, for example, is non-compliance issues. For licensure issues, it's about 1 year, but if it's for violating a particular Medicare policy, such as using a false certification statement, that could be 3 years. So we'll see in some grounds for revocation, there's some latitude for CMS to determine the re-enrollment bar, but otherwise they will be fixed based on severity. And in addition to, effectively the provider or supplier losing their ability to continue participating in Medicare, there are a lot of other potential derivative effects that a provider supplier's revoked faces. Revocation may give grounds for termination under other provider agreements and Medicaid programs. You'll often see language in those agreements or policies from state Medicaid programs stating that they will be terminated or give the right to terminate if a provider supplier is revoked under Medicare. Usually what we see when a group practice of practitioners, such as physicians, is revoked, if the entity is revoked, all the individual practitioners become deactivated. We'll talk about the difference between revocation and deactivation later on in this presentation, but it is a nuisance issue in terms of billing and other consequences that deactivation may have, including the requirement to re-enroll if the individual provider wants to continue participating in Medicare. Another thing to keep in mind is if one of the Medicare administrative contractors revokes a particular provider supplier that participates with multiple MACs or is Part A and Part B provider supplier, we'll see that the requirements require the provider to provide notice to all other MACs, so all other contractors that administer Medicare, that they were revoked by one of the other MACs. This is important because failure to provide that notification can be grounds of revocation in and of itself. So let's talk about claims for services furnished before revocation. What can a provider supplier expect in terms of receiving revenues from those claims prior to revocation? Well, there's a 60-day window after the effective date of revocation for the provider to submit all claims furnished before the effective date of revocation. However, in certain instances, we see that this window to catch up on claims pre-revocation doesn't exist. This doesn't exist for home health agencies and doesn't exist for those grounds of revocation, such as felony conviction or non-operational status, which can be retroactive. So in other words, if CMS is imposing a revocation going 2 years back, there won't be an ability to catch up with claims prior to the receipt of the revocation letter from CMS. And in conjunction with that, as Rob mentioned before, these kind of retroactive revocations in particular can lead to overpayment liability and demands for recoupment of overpayment if a provider is found to be revoked retroactively. The contractor, Medicare administrative contractor, can theoretically go after all services paid after the effective date of revocation as overpayments. So MACs are primarily responsible for overseeing the enrollment activities, but they nonetheless cannot issue revocations on their own for the most part without approval from the provider enrollment and oversight group. There are certain exceptions to that, such as certain non-compliance revocations, the CMS enrollment fees not being paid, and the home health agency capitalization revocation grounds. Those grounds the MAC can go ahead and revoke without the PEOG, the provider enrollment and oversight group, but otherwise all revocation requests go through the PEOG before they're finalized. Zone program integrity contractors also can refer revocations to the PEOG. This isn't as common. They're ZPICs, as we call them, are non-governmental contractors who audit providers, and they typically look for overpayment liabilities, but they may uncover certain revocation grounds during the course of their investigation. If they find something like that, they'll send it to the PEOG, which will make a decision about revoking a provider. And the PEOG obviously has the authority to revoke or approve referrals for revocation. Sometimes it doesn't just come from MACs or ZPICs, it comes from other government agencies such as the OIG or the Department of Justice. But the PEOG is a central group in CMS that oversees these kinds of revocation matters.
Okay. Revocations can affect individuals, but they can also affect organizations. And what we'd like to do is highlight a particular feature of this regulation that applies to organizations where the organization itself may be completely faultless, but it may be subject to a revocation based on an individual's conduct, and sometimes the underlying offense may have nothing to do with the organization's business. Under the regulation, CMS can revoke the enrollment of an organization if they have a managing employee, an owner, certain other clinical personnel such as medical directors or other healthcare personnel that have been the subject of other actions, an exclusion or a debarment or a wide range of felonies that have occurred within the past 10 years. Again, these can be offenses completely unrelated to the organization's business and can go back 10 years. So a healthcare provider could have a managing director or a medical director convicted of insider trading and be subject to a revocation. It's a very, very broad club that CMS has to enforce what they consider program integrity. And again, the organization itself could be completely blameless. It's a very broad authority, but there is a safety valve that's built into the regulation. It allows the organization to escape liability if it can demonstrate that it severed all of its business relationships with the individual who's been convicted of the felony, and they do it within 30 days of receiving notice from CMS. Yulian and I have been involved in a matter just like this, and the organization was able to escape liability because they were able to document it extraordinarily well. They had corporate minutes from their board of directors meeting where they formally severed the individual's employment agreement, all ties with the organization, put it in the record, and we had to present it to CMS so that the entire organization would not be excluded from Medicare. As I said, the documentation really has to be quite thorough. Sometimes a letter that says, we haven't done business with Dr. X in 18 months may not rise to the level of persuasive evidence. So it's an important safety valve, but one that you really have to have on the books, and you have to have it ready to go. And we'll show you why that's very important for the purposes of hearings.
And Rob, just staying on the felony convictions question for a second, it's a little broader. The definition of conviction is a little broader than just a conviction by a judge, right? It's acceptance of a guilty plea and certain other circumstances which can really extend this period of when the particular individual causing this revocation was given a felony conviction under the definition.
That's right. Guilty pleas are the same as a finding after a trial for purposes of a conviction or for CMS's purposes.
So if we have a deferred sentencing situation where a person submitted a guilty plea but it hasn't been adjudicated yet, the effective revocation date can go back to when the guilty plea was submitted, right?
That's right.
Okay, so another type of case that Rob and I worked on together, on-site review, we talked about it briefly before. This is when you have a MAC or ZPIC take a visit to the provider's practice location as listed on Medicare provider enrollment forms. So the common issues that we've seen, the practice location is listed as a P.O. box, which is not permitted under the Medicare guidelines. Sometimes they will see that it's a post office or UPS store, mailbox, and without further inquiry, the surveyors, the MAC or the ZPIC will issue revocation as non-operational practice site. Sometimes the issue is that the individual visiting the practice site determines that it looks empty. I think, Rob, you had a case like this where I believe someone posted a sign on the door that led the surveyors to believe that the practice location was not functioning.
That's right.
Yeah, so they don't even have to ring the doorbell. They could potentially make that determination. So again, this is the definition of operational that I mentioned before. One thing I want to point out is this bolded and emphasized language, because we've seen some recent DAB cases, administrative appeals, and decisions that don't address this issue as strictly as the regulations suggest. They will look into the type of facility, type of provider organization. This is important for mobile-based providers or suppliers where they don't have to have a physical site. This is important to show that, for example, a doctor that goes to facilities and hospitals doesn't have a main office is still operational even though they don't have a physical location because they don't need one. That's their business. So something to keep in mind that seems to be a turning tide in terms of enforcement and how the DAB interprets these type of operational issues. So some other special rules for organizations, the billing numbers. We touched upon this briefly before, but essentially what CMS is trying to prohibit is a provider supplier knowingly selling or allowing someone else to use its billing number. Again, this isn't a reassignment. We're not talking about reassignment situations. Those are fine, but we're talking about when someone is billing under a different provider supplier's name than should be. This is a minimum 3-year re-enrollment bar, and as we talked about before, it could come with other potential ramifications from other government agencies.
Revocations are fairly important. They are devastating to some organizations. I just want to take a moment to distinguish that from deactivations. That's another program integrity initiative that CMS has under their regulations. A deactivation can occur if an entity or an individual has not submitted a claim within 12 months, or if certain information on the enrollment form is not reported, changes in enrollment are not reported within 90 days. It differs markedly from a revocation, because if your enrollment is deactivated, you can typically correct the information and then you're back in the program. It's not a 2 or 3 year bar, again, assuming that there are no other changes. So given all of these remedies and all these authorities that CMS has, what can you do if you're the subject of a revocation? First, there is a very specific appeals process that's laid out in the regulations. There are 3 levels of administrative appeal, and the important thing here to remember is that if you are the subject of a revocation, it is imperative that you put all of your evidence into the record as soon as possible at that first level of appeal, because if you don't, this is the big takeaway from this slide, if you don't put all of that evidence in at that first level of appeal, you're barred from introducing new evidence or new testimony or anything else into the record. And that's why it's very important within that first 60 days after anyone receives one of these notices that you submit everything that you have to submit. And hopefully everything is taken care of at that first level of appeal. Now, since this is a pretty draconian measure that CMS has, there are some providers and suppliers that want to short-circuit the administrative appeals process. They want to go directly to court, and they want to try to get an injunction to prevent CMS from doing this. These have not fared very well at all. Last year, a very large medical supplier had their Medicare enrollment revoked because it was alleged that they had supplied or they were billing for deceased individuals. They came into court, they made a raft of statutory, constitutional, administrative arguments, and within several days, the judge came back with a decision going through every single argument point by point, knocking them all down and saying, no, your due process is you have to go through the administrative appeals process. I am not going to get involved, and I'm not going to stop the agency. So, as I said, it's terribly important that you marshal all of your evidence, get it in as soon as possible. But I do want to come back to a point we made before. If an organization has its Medicare enrollment revoked because of the felony conviction of an owner, operator, employee, etc., it can still rely on that 30-day window to submit the evidence showing that you've severed all business relationships with that individual, and if you're successful, escape the entire process. The regulations, in addition, also have an option for corrective action plans, but keep in mind these are typically for lower level non-compliance. It's usually you didn't fill out the form properly. A corrective action plan allows you to stay in the program, but it's not available for the type of fraud cases that we were talking about before, or convictions, or the more serious matters. So we have a few minutes left, and I think I'll turn it back over to Adam.
All right, well, thank you for joining us. This concludes today's webinar. As stated earlier, in approximately 2 to 3 business days following the webinar, Epstein, Becker, Green will communicate the availability of the webinar recording and access to the PowerPoint materials.